It's 6 a.m. on Saturday morning. I'm out here on my walk on the walking trail. About 30 feet ahead of me, there's a pair of coyotes trotting away from me, thankfully. Hi, guys. I'd show you, but then you guys would know where I live, so we're not going to do that. I did a duet on my backup account last night, but I'll mention it here, and I'll do a longer video today. A federal judge in Los Angeles issued a ruling late in the day yesterday shutting down ICE's racial profiling tactics, saying that there is a mountain of evidence that ICE is violating the Fourth Amendment rights of the people that they've been detaining by doing things like going to a Home Depot and just snatching up every brown person they find, because according to ICE, that's indicative of someone who is violating immigration law. After Tom Homan, the head of ICE, got on Fox News and said, ICE agents don't need probable cause. If you're at a Home Depot and you're brown, that means that you're likely in violation of immigration law. That's not the way the Fourth Amendment works. A constitutional right against unreasonable search and seizure. So that's a pretty huge thing. And given the Supreme Court's recent ruling, I'm sure that there are attorneys in other jurisdictions who are in the process of certifying a class of immigrant detainees across the country within a class action lawsuit so that they can get a nationwide injunction against that kind of behavior and activity on the part of ICE. As we saw happen a couple, 3 days ago in a birthright citizenship case out of New Hampshire, after the Supreme Court issued a ruling last week or the week before taking away lower courts' rights to issue nationwide injunctions against Trump executive orders, except for within the context of a class action case. Trump hailed that ruling as a huge victory, and that victory lasted about a week. So there is a nationwide injunction against Trump's birthright citizenship executive order, and there will be one shortly against ICE's egregious racial profiling by saying, well, if you're a brown person and you're working as a day laborer, or if you're operating a food cart, or working in a food truck, or working in a hotel or a restaurant, by definition that means that you're violating U.S. immigration law without any specific information that those people are actually doing that. That is simply not the way the Fourth Amendment works. The only people within the government so far who are actually standing up to this fucker are judges at the federal trial court level, the district court judges, and they're doing a great job. So we'll see how this one develops. As you can see, we're a little fogged in out here. It's a balmy 51 degrees north of San Francisco. There's a little breeze. It's chilly. I hope everybody has a good Saturday.